Welcome friends to our next webinar on IBC. As regularly bi-monthly we are having that. So thanks for joining. And today's topic is status of crown debt in IBC Code in India. Because this crown debt situation is different in different country. So in India, what is the context and how it is taking shape in future? And in past, we are discussing that. And we have, as usual, our presenter, Jasveen Bindra. And also I have my colleague, Mr. Hemendra Paliwal. Mr. Paliwal, partner of Mehta Mehta Insolvency and Restructuring LLP. Mr. Paliwal, please. And thanks for joining us today as a co-panelist. And with us, of course, today, our special guest, Mr. Anchit Kumar, is Assistant General Manager, MMZO Central Bank. Welcome, Mr. Anchit, for your time. Thanks for giving your time and giving us time to share your inputs on the topic of crown debts, because it affects very much to the financial creditor. If any change in the crown debt position or the preference in IBC is done, it affects very badly to financial creditor. To introduce Mr. Anchit, Mr. Anchit is a Bachelor of Science from Patna University, and he has done Diploma in Business Administration from Symbiosis for distance learning. His professional qualification is GAIB from IIBF, CAIIB from IIBF, Cost and Work Accounts from ICAI, and limited insolvency examination from IBBI. Oh, sir, you are our colleagues. So his experience, he joined Central Bank of India in year 2002 and have worked in various departments of bank. And some of the highlights are, he joined the bank as assistant manager in the year 2002 and worked in the same cadre till 2009. And whereafter that he was promoted as a manager, and worked as a faculty member from year 2011 to 13 in the training center, and also secured as a position of senior manager and later chief manager. Since then, he has worked in Forex, human resource, and finance and account department in the bank. Currently, he is overlooking recovery, credit monitoring, and HRD of Mumbai zone. Welcome, Mr. Anchit. Thanks a lot for your time. And I will now request Mr. Paliwal to say 2 words on the topic and his view, and then I'll request Mr. Anchit to give his view, and then Ms. Jasveen can start the presentation. Over to Mr. Paliwal.
Thank you, Dipti ma'am. And hello, friends. When Jasveen said we will be doing a seminar on a crown debt, the term is stuck to mind. What is crown? Why we call it crown debt? So that's why I started searching on a web, what is crown and why we call a government liabilities a crown debt. I thought these are being highest liability, highest in order. That's why crown has been put on them. But case was not that. It is basically any debt payable to a crown. That's why it is known as a crown debt. And post implementation of the Constitution of India, we have Article 372(1), which says that any act which has been enacted before the enactment of Constitution of India, those acts will be continued if either they are expressly repealed or modified. Since those acts are still being continued, that's why we still say a government liability is a crown debt. That's why we have today's seminar on crown debt. A lot of insight will get throughout the webinar. We have category covered maximum points on a crown debt. That's the initial brief from me. Thanks a lot.
Thank you. Mr. Anchit, can you put some words and your thoughts on the subject, please?
Yeah. Thank you, ma'am, for including me as a panelist and giving me opportunity to share the view with professionals. And since I was ICWA, so I got the opportunity to pass the examination of IBBI at earliest stage in 17, and so that I can give inputs to banks and my bank get benefited. and we are having many cases related to IBCs. At least presently, I think we are handling more than 40 cases related to IBC, and we are the recent verdict affects us also of the Supreme Court in Rainbow paper. So this is very valid topic for all, and I welcome all the participants on my behalf and on behalf of Madam. This discussion will be very, very fruitful and will be very knowledgeable to everyone, and we will be able to implement in a smooth manner, and we will understand the hurdles what we are coming, how to overcome it. Thank you, Madam. Over to you.
Thank you, sir, for your inputs. Yeah, Jasween, you can start this.
Good evening to one and all. It gives me immense pleasure to address this with these esteemed panelists and the participants. So a very pertinent topic and one that has been discussed a lot due to the current developments is the status of crown debts in IBC in India. So like Hemendra sir said, it got me wondering as well, what are crown debts and how has this term come up? So crown debt basically refers to the statutory dues and includes income tax dues, excise, customs, GST, VAT, and basically any other form of due that is payable to the central government, state government, and or oblique to the local authorities.
Basically to power, how the crown is a power.
It is a more British way of addressing this, since yes, so that has come out from the UK style of presenting statutory dues as a crown debt.
Yeah.
So the treatment of crown debt before the IBC came in, due to pre-independence legal regime, crown debt enjoyed a lot of priority over any other due. As far as recovery and winding up or insolvency was considered. Section 327 of the Companies Act 2013 placed dues to the central government and state government or any other local authority at a first priority in the waterfall process, because that was the one that was to be paid initially. So that is the kind of priority it enjoyed prior to the IBC coming in. However, when the discussion started taking place of revamping the entire insolvency regime, and the first interim report of BLRC was presented in 2015, the report said that the preferential status given to government dues can be traced back to the UK law, and they placed arguments in that report against giving such preference to crown debts by stating that government already has ample, is able to adjust the tax levels in the manner that anticipates any kind of defaults in the debts. Second, the dues pursuant to tax or any other dues is quite insignificant as compared to the total government receipts, which means that the government already has multiple sources of revenue other than these dues, which is not available to the private sector. And third, it said that the government has other means of enforcing their debts as well, which is also not quite accessible to the private sector. Hence, they noted that the preferential status given to the crown in winding up stands on very shaky grounds, and it was considered to change this entire regime. Moving on, when the BLRC final report was presented, it categorically stated that the right of the central government and state government in the distribution waterfall, as it stands today under Section 53, shall be at a priority below the unsecured financial creditors. That means they had gone down in the entire waterfall mechanism as a status of debt. And the reason given for that was to promote availability of credit and developing market for unsecured financing. Another argument that they had placed for the same in the BLRC report was that all these measures of ensuring availability of finance, reducing cost of credit, would ensure a better economic growth, which would ultimately benefit the government itself. Further, while introducing the Insolvency and Bankruptcy Bill in the Lok Sabha, Shri Arun Jaitley, the then finance minister, had included in his address that the rationale for bringing the taxation authorities lower in the priority order was because if the taxation authorities were brought on the top, then they would get a huge part or maybe the entire part of the resolution amount, leaving nothing for the workmen, banks and financial institutions, which would be unjust. As on date, the IBC in its statement of objects and reasons, which stands on the top before we begin reading the code, it states the purpose of the code, which mentions that the main motive of the IBC is to balance the interest of all the stakeholders, which includes making alterations in the order of the priority of payment of government dues.
Yeah, Jasleen, I just want to add, before implementation of IBC, there was a completely full priority of the government dues were been given. And initially, when actually IBC implemented, and when few initial cases started coming in, it was a disbelief of corporate world, where even any IP used to visit to a corporate customer and communicating them, sir, there is a new law which has come, and which says ki government dues do not get a priority, which was a complete disbelief for a corporate world. Even the chairman, legal officer, they were used to accept this as a fact. And they used to argue, yeah, how can a government dues can be a subservient to the any other debt of the company. Even for me also, it was a little difficult to adjust ki, there is a law in the country which give a priority to the secured lenders over the government lending, because we lived our life throughout the professional career before 2016 or 17. We have seen maximum cases are being going where the government is coming behind the corporate and taking away the whole asset of the company to recover their dues. So it was really welcoming changes, IBC, and it has given a lot of comfort and relief to a corporate world by categorizing a ground date or government dues to junior than the secured creditors.
Right.
That's from my side.
Right.
So with this intention of the entire code or understanding how to interpret it, we have just set the stage for discussion as to how has the actual journey of IBC been thereafter. So there have been multiple case laws in line with this legislative intent of keeping of a conscious effort of the government of keeping government dues lower in the priority or subservient to the other dues. Some of the judgments are Sundaresh Bhatt, the liquidator of ABG Shipyard versus Central Board of Indirect Taxes and Customs. It's a Supreme Court judgment wherein the conflict was whether the Customs Act would override or the Customs Act provisions would override IBC. So it was said that the IBC, being a more recent statute, clearly overrides the Customs Act. And the Customs Act has a specific provision which states that the custom authorities would have first charge of the assets of the assessee under whenever the company goes into a liquidation. However, the Supreme Court had stated that Section 238 of the IBC overrides any provision that is inconsistent with IBC. And the Customs Act and IBC can be read harmoniously in a manner where the authorities can submit their dues and the quantum of their operational debt. However, in the order of priority that is placed under 53 of the IBC, that would be the treatment given to the dues of the Customs Department, and they would not get any preferential or a first charge over the assets. The second judgment was the Principal Commissioner of Income Tax versus Monetis PAT and Energy Limited, again a Supreme Court judgment wherein the income tax dues were considered, and it was stated that income tax dues, being in the nature of crown debts, do not take precedence even over the secured creditors who are private persons. And they had also again highlighted that if there is any disparity between Income Tax Act, which places Income Tax Department dues on a higher priority, versus the IBC, which has its own waterfall mechanism under 53. It will be the waterfall mechanism under IBC that will be preferred for the purpose of implementing the code. They relied on another landmark Supreme Court judgment in Dena Bank, which had stated that crown debts cannot get a priority, and it should be the secured creditors who should be given the preference under IBC.
Jasveen, is just corporate world was in shock. Even the government departments was in shock.
That is right, sir. It was a very big wake-up call. I remember
they also reacted in same way the way corporate world reacted. So corporate welcomed it because it suited them, and a government department probably resisted, protested, went to appeal to ensure that their rights are being protected as a government recoveries.
Right, sir.
That's why many cases have been went up to the Supreme Court to get a justice key why crown debts is not getting priority and we are being hardly getting any money in resolution plan.
Yeah, even still in the remote area, the government officers still fight with us. And, when we say that you have to file the claim and all that, they say how you can do this and you have to explain, send the provisions and all that. Takes time to digest that. It takes time.
Absolutely.
Yeah, please.
Further, this was the High Court of Hyderabad in Leo Edibles and Fat Limited versus Tax Recovery Officer, wherein it again, as regards an income tax due, it held that income tax department cannot claim any priority merely on the fact that the order of attachment has been issued against the corporate debtor. As long as so even prior to the liquidation, they had an order for attachment. However, they had said that still you cannot claim any priority and you will have to follow the distribution mechanism as per 53. And they had particularly said that section 53(1) provides the order of priority for such distribution of any amount that is due to the central government or the state government. It comes fifth in the order of priority. So it should be placed at that, and there is no secured creditor right that can be enjoyed by the government.
Yes, they were asked to leave their attachment. You can't have attachment on property under IBC, and entire process of resolution will take place as per the IBC code. And you need to relinquish with your attachment and give the property to RP to proceed for.
Right. Then there was another judgment. This is in view of more of the SARFACI and RDDB Act, which is Recovery of Debt Dues Act. But since it has a similar object of insolvency and debt resolution, so in Jalgaon Janta Sahkari versus Joint Commissioner of Sales, the Bombay High Court had held that the tax dues are subservient to the secured creditors' dues, and even the use of the word or the first charge right that they have cannot be considered to be paramount to any other charge.
Yes, this both act were being amended somewhere in 2016 and actually implemented in 2020. There was section 26E in SARFACI and 31B in a RDDB Act, which has been modified. But in case of SARFACI, there is a very peculiar thing which you need to see. Any secured creditor can be considered a secured creditor only if he registered his charge in SARFACI. If the charge is not registered with SARFACI, he becomes unsecured. If anybody wants to proceed under SARFACI, secured creditors should register their charge under SARFACI. Even government department, if they want to proceed for the secured recovery, they need to create a charge under SARFACI. So there is a peculiar thing, but that is not in IBC. If you don't have a SARFACI charge and you have still security, you can proceed with the IBC. But SARFACI has a peculiar nature. If you don't have SARFACI charge, you can't be categorized as a SARFACI and you can proceed as a secure lender. But this judgment has confirmed that in case of SARFACI and RDDB, secure lender will get a priority over government dues or crown dues.
And more than that, so it went on to say that even if you have a statutory provision in the Act that states that you have a first charge, that can still not be considered paramount to other debts, other secured debts of the corporate debtor.
Like in the same way for IBC, for FC, they are checking the MCA registration as a prime documentary proof for registration of charge. Yeah, just
Charge registration.
Now IBC also slowly going towards the entities who make all database ready for the IP.
yeah.
And probably we'll get a lot of data directly from our data. I don't just what we call him?
Information utility.
Information utility.
IU.
IU. So we'll get a lot of insight on the CDs, borrowings and other claims
Yeah.
directly from IU.
That is right.
Yeah, just.
Then the very famous judgment that is that every resolution professional is very well known of with Ganja, Mishra and Sons versus Edelweiss Asset Reconstruction Company Limited, wherein the Supreme Court had stepped in and particularly said that any debt in respect of payment of dues arising under any law, which includes the central government, state government or local authority debt, which is the crown debt as we are calling it today, it will not, if it does not form part of the approved resolution plan, it shall stand extinguished. Further, it went on to say that an approved resolution plan which has received the consent or the approval of the Honorable NCLT shall be binding on everybody, including the government authorities as well, and they cannot go ahead and file litigations against it later on.
Correct. In this case also, income tax went ahead and filed the application. They have a lot of huge outstanding against the company. And in the resolution plan, they got hardly anything. And that's why I say how the government dues can be extinguished like this. And they insisted that we should get our recovery dues. We can't waive off the entire right of receiving the money. That's where they went up to the Supreme Court, where finally a Supreme Court says there is a new enactment IBC, and from an IBC perspective, if any resolution plan which has been approved by adjudicating authority and this is in compliance with IBC Code, then the plan is final document, and none of the government agencies will have any additional claim after the approval of plan. Whatever the amount which has been mentioned in plan, they will get it. A rest or liability will be extinguished.
Right. So all these judgments kind of confirm the legislative view or wherein the judiciary is supported and refer to the legislative view of placing the government dues lower to the priority as regards secured creditors are concerned. And the section 53 waterfall process was explained by them. However, the major wake-up call came when the Rainbow Papers judgment came in, which caused a paradigm shift in the entire approach as regards the treatment of statutory dues is concerned under IBC.
Correct. Till this point of time, the intent of the law has been upheld by Supreme Court. And all major judgment which has come from up to the Supreme Court were in line with the intent of the Act. After all these judgment, the Rainbow Paper is the paradigm shift and literally went against the law, what law says. So let's hear from you what this judgment is all about and what ripples it is creating.
Right, absolutely. So going to the facts of the case, the matter that was to be decided by the Honorable Supreme Court was that an appeal was filed against the order of the Honorable NCLAT, wherein it was held that the appellant, being the sales tax officer at Gujarat, cannot claim first charge over the property of the corporate debtor under Section 48 of the Gujarat VAT Tax Act, wherein it is particularly stated that the first charge would be created over the property of the dealer in respect of any amount that is due and payable in respect of tax, interest, or penalty under the Gujarat VAT Tax Act. So they said that this cannot be done. We cannot create a first charge of the sales tax department or the VAT department over the property, because this is contrary to Section 53 of the IBC, and therefore Section 53 would prevail. That was the NCLAT judgment, which was challenged before the Honorable Supreme Court. Now let us see what Section 48 of the Gujarat Value Added Tax Act 2003 talks about, and why is it creating, or how is it creating a preferable charge for the department. So Section 48 states that notwithstanding anything to the contrary contained in any law, being the non-obstain clause, any amount payable by a dealer or any person or on account of the tax, interest or penalty for which he is liable to pay to the government shall be a first charge on the priority of such dealer and as the case may be of such person. So the first charge on priority or first priority on the
First charge on property.
right, first charge on the property of the dealer would be given to the for the recovery of such dues under Gujarat Value Added Tax Act. Now let's see what arguments were placed before the Honorable Supreme Court, which led to passing the judgment that was passed. So first of all, they said that the resolution plan, which had said or stated that the government dues would be completely waived off, was challenged before the Supreme Court. The main contention that was used was that due to Section 48 of the Gujarat Value Added Tax Act, the Gujarat Sales Tax Department becomes a secured creditor within the definition of IBC, and therefore would be higher in priority as secured creditors are treated under 53. Further, they said that merely because the government department is considered to be an operational creditor, it cannot lose its status as a secured creditor as well of the company. And since the government was not able to recover any amount and their dues were waived off, it was the contention that was made was that this is absolutely in contrary or in contravention to Section 32B of the IBC, which states that the operational creditors must get at least the amount that they are supposed to get during liquidation under Section 50 of the IBC. Hence, this resolution plan could not have been approved in the first place, or not even be considered for that matter by the resolution professional for approval purposes. Having seen this, let us now understand what the Supreme Court, the Honorable Supreme Court has held in this matter. So it was decided in this matter that a statutory charge created by virtue of Section 48 of the Gujarat Value Added Tax falls within the definition of security and interest under 331. And therefore, the government department becomes a secured creditor under 330 of the IBC. Further, they stated that because the secured creditors, the operational creditors in this case were not given the priority of under 53 or the minimum payment under Section 53, the resolution plan did not meet the requirement of 30 subsection 2 and would be invalid and non-binding on the central government, state government, and any other statutory authority. Further, the Honorable Supreme Court went on to state that if a company is unable to pay its debts, which would include statutory dues to the government or any other authority, it would necessarily have to be liquidated. That is, it is not even in the capacity to pay its government dues by way of the resolution plan and its implementation. So you will have to shift to liquidation process then, which is a little contrary to the motive of the act or the intention of the act. But this is basically to state that you cannot waive off government dues while considering a resolution plan.
Let's have Anchit sir view on this, because this is hitting very hard to bankers.
Now, after coming of this judgment, the few cases of our bank held up, and we are not able to proceed what to do earlier, and the situation got tangled. We were in touch with all of you professionals to resolve the issue. Our still I think there is no tangible effort at least I have seen. I think government has come with something, but I am not clear on this front for whether whether the present priority, what is the present priority being implemented by RPs. You will be the better judge on this count, and you will highlight on this fact also.
Yeah.
Thank you, ma'am.
Yeah, thank you. Jasveen has covered this, that what is the current scene actually.
Yes,
We just touch on this this judgment. Basically, this judgment has completely shaken the fundamental of the IBC.
Yeah,
IBC code was implemented with a objective,
clear understanding. Yes.
clear understanding and resolving the issue of the company. Now they said if the company is not able to pay the taxes and better liquidate, probably the all decisions which you have seen, almost 80-90% company will be liquidated. If that is the stand of the law. If law says if you are not able to meet the commitment on the government liability side, crown debt side, it should be liquidated. And the purpose of IBC was to create a level play field for all multinational companies, domestic bank, financial institution. When they lend to a business, there should be a reasonableness if something goes wrong. When we go for a resolution of the business, there should be adequate protection given to them to get the recovery back. If this case law is being implemented under IBC, the recovery will be very minimum for a secure creditor. Unsecured creditor, so you forget it, because what we are saying ki even the secured creditor hardly get a 20%, 30%, 50%. If you get a government dues as a priority under IBC as well, the recovery will be very minimum for the secured and unsecured creditors.
No one will recover anything.
And it will be very tough for even RP to proceed for the cases where he wants to genuinely want a decision to take place, because in maximum cases, lot of claims come from government department, which has with very high interest rates and penalties given to them. So at the CRP commencement, what we see is that the claims which were lesser because of the interest and penalty that become very big. And somewhere RP has to accept those claims because these are being backed by a law. So even though solution plan may not provide for it, but while initiating CRP, he need to admit this claim, and which pose a greater challenge for the RP, or even for that purpose of COCR lenders, they also face a challenge because
and even applicant.
All applicants face a challenges.
Everyone,
The same problem is being faced by liquidators as well, where they see a lot of government liabilities are being lined up, and they are not able to decide how to go about in liquidation.
Right. Just
the major issue in this judgment has been that all the judgments that we have read prior to this have specifically stated that IBC would override any other provision. So even though income tax had such a provision of first charge, and so did Customs Act, but they said no, IBC would prevail over everything. However, in this judgment, they say that Section 43 of the Gujarat VAT Act is not at all contrary or inconsistent with Section 53 of the IBC. And they state that Section 53(1)(b) provides that the debts owed to the secured creditors, which now would also include the Gujarat VAT tax, would rank equally with the debts that are owed to the workmen.
Correct.
So that is the entire position, wherein we have particularly given the status of a secured creditor to the government department, and we have said that even if the security interest is created by operation of a law or by way of a statutory provision that is given, that would still be considered in the ambit of a security interest and make the government department a secured creditor. Which is why when this judgment came in, all the other departments also, say income tax or every other government department also, it was a big wake-up call for them, so that they could go ahead and claim their debts in priority.
Yes.
So observations and the implications of the Rainbow Papers judgment. The first observation on this judgment is that they have regarded government dues to form part of security interest or any government provision under any law to give right of priority or as a secured creditor to the government. However, Section 331, which defines security interest, particularly states that it would mean a right, title, or interest or claim to the property created in favor of or provided for a secured creditor, but it should be pursuant to a transaction. Further, Section 333 defines the term transaction to include any agreement or arrangement in writing for the transfer of assets or funds, goods or services from or to the corporate debtor. So, while including a charge pursuant to a statutory provision in the term transaction and therefore security interest, the Supreme Court has gone far-fetched and stretched the concept of statutory due a lot in that manner. The implications of the judgment, the legislative intent of keeping, like we've all discussed, that the legislative intent of keeping the government dues subservient to the dues of the secured creditors has absolutely failed by way of this judgment. Further, it has led to excessive litigation and delay in the entire the approval process of the resolution plan, since a number of government departments have come forward and objected to the approval of the resolution plan after this particular judgment. It has also become difficult in implementing the resolution plan due to pending litigation that has been filed by government departments. So there are certain judgments that came in after the Rainbow Papers judgment, which have wherein the government authorities have received a successful order and received priority in accordance with or in view of the Rainbow Papers judgment. These judgments are Parag Sheth, the liquidator of Sai Infosystem India Limited versus the collector of Ahmedabad. Under this, the NCLT Ahmedabad bench had given priority to and treated property dues as a preferable secured creditor under Section 53. The second is Principal Commissioner of Income Tax versus Sam Company India Limited, wherein Income Tax Department was also given priority by NCLAT New Delhi in view of this.
This is surprising because if you say Income Tax Act itself is modified for this reason.
Yes.
After IBC. Because I have given various lectures to income tax officers and given the training on IBC. And they were literally fighting and remember, telling that particular section. And I used to tell, please check, it is now amended. It is telling subject to IBC. So if there is a provision and it is subject to, but I'm surprised still it is done.
Yes, NCLT New Delhi had asked, had particularly said that NCLT should take the view of Rainbow Papers and therefore give priority to Income Tax Department for the recovery, for the process of resolution. However, there have been certain judgments that have drawn a distinction between Rainbow Papers as well as the current position. And some of that include Excise and Taxation Commissioner, Haryana Sales Tax Department versus Jalesh Kumar Grover. It is a NCLT Chandigarh bench judgment, which is coming after the Rainbow Papers judgment. So here the objection was filed against the approved resolution plan by Haryana Sales Tax Department more than 1 year after the approval of the plan. So the NCLT Chandigarh bench held that due to they had particularly deferred and with the decision of the Honorable Supreme Court in Rainbow Papers and had laid down that it is not applicable to the facts and circumstance of this present appeal, more so because they have filed this objection 1 year after the approval process, which would actually derail the entire efforts of resolving the company and the intention of the law to first resolve the company and get back the company to its feet. So the NCLT Chandigarh bench absolutely deferred with this judgment, and they said that the Rainbow Papers judgment should be read in light of the facts and circumstances of that case.
Exactly, this is the required. It can't be applied to everyone. Each
Absolutely.
decision has its own facts and circumstances. It is GVAT. And these are all different statutory dues. You can't apply that way everyone, and each case is a different case. That's a really good judgment this is.
Yes. Similarly, the NCLAT New Delhi in Kalyan Dombivli Municipal Corporation versus NRC Limited. Again, a very good case law where it stated that you cannot make rainbow papers just a common judgment for all. So under this, Kalyan Dombivli Municipal Corporation had filed an appeal against the NCLT order approving the resolution plan. And they had stated that though the municipal corporation had not filed any dues with the resolution professional or filed any claim with the resolution profession as regards the property tax, they claimed that in view of the rainbow papers judgment, it was the duty of the resolution professional to take in account the property tax and give them payment, a priority payment in view of that judgment. However, what the Honorable NCLAT held in this case is that there is an absolute deference in the view of first in rainbow papers, they had gone ahead and submitted the plan and therefore submitted the claim and therefore claim priority under it. However, in this case, we cannot go far-fetched and request consider the resolution professional himself to consider the claim without filing of any claim document and then get priority in resolution. Also, the other observation that the NCLAT Delhi had was that we should not we should always, while interpreting the situation of crown debts, we have to keep in view the judgment of Ghanshyam Mishra and Sons as well, which states that once the resolution plan is approved, all the other claims shall be extinguished and it shall be binding on all the other creditors. Further, there was a legislative move as well after this judgment, wherein there was in the recommendations made or the proposed amendments made to be made to the IBC, we did the MCA notice dated January 18, 2023. There is a specific paragraph 14 which is included to state that the central government and state government dues should not be treated as secured creditors merely by operation of law or just because there is a provision in law that gives them priority. It would not be just and equitable to do the same, and they should be treated as an unsecured creditors only unless there is a particular transaction that the government has with the particular corporate debtor that gives them that priority.
Yes, wherever the government department has created a charge especially against the asset for a recovery, that can be acceptable as a secure creditor, where they have created a security and they say we want to proceed against this asset because we have actually filed a security interest against this. But unfortunately, after this judgment, lot of litigation has also increased, and where the RPs are facing music because ultimately all resolutions which they are bringing on the table, these all cases are either going to Anchit or Supreme Court because every department wants to test whether they can get the money for their department. So a lot of litigation has been increased because of this.
Yeah.
More so, I think so. It could only be the legislature now or another Supreme Court judgment that can particularly state that you have to keep the facts in mind while considering it, and you cannot apply rainbow papers just as a common law principle.
Right.
So moving on to the conclusion and the gist of the entire situation as on date for crown debts. Like it was discussed in this during the course of this webinar, that the rainbow papers judgment cannot be held to be the rule of law, and you have to keep in mind the facts of a particular case while interpreting it. Second, it is very important to keep in mind the objective of the Insolvency and Bankruptcy Code and go back to the BLRC reports and intention of law when we are interpreting law. or interpreting any provision thereto. Also, if when these proposed amendments under IBC, and if this particular amendment that they have intended to make, wherein it's stated that statutory dues only pursuant to government dues pursuant to a statute getting a secured creditor right will not be considered as the correct interpretation of law. If that sails through, then it will clear a lot of doubt that is there in the mind of the professionals as well as the government departments there too. Thank you so much. Ma'am, your inputs on this entire topic, since we've come to the end of this webinar.
Yeah, thanks, Jasveen. It was wonderful, clear. Right, Mr. Anchit, what is your view on the presentation and the topic as such?
The topic was rightly chosen, madam, and the deliberation was good long enough to comprehend the whole fact. However, the things remain that every NCLT, NCLAT, and will think accordingly as per case, but confusion remains until the government will bring amendment, and it will not pass by Parliament and its assent of President. It will create the problem, as it is creating problem, as well also as like personal credit, personal guarantor, insolvency and bankruptcy and personal guarantor cases is also being held up.
Right.
And similar way, this will also will be held up. However, it was pleasure to be with all, and there was a valuable input from all. It has been honor for me to be part of this accomplished individuals and professionals, and the whole perspectives are presented in a nice manner, and I think every participant would have been benefited, and it will be good for his professional career. Thank you, ma'am.
Thank you, sir. Thanks for your time, and it's our pleasure, and it's our we are very happy that you devoted your time. Thanks a lot. It's a pleasure for us to welcome here. Thanks a lot. Thanks, Mr. Paliwal, for your inputs and your contribution. Thank you. Thank you, Jasveen, for wonderful presentation. Thanks all participants. Again, after 15 days, we'll come with new topic. Till that time, thanks a lot.
Thank you so much.
Thank you. Thanks all. Thanks.